appeal in the matter of Paul and another and Royal Wolverhampton NHS Trust, Polmear and another, and Royal Cornwall Hospital NHS Trust, purchase and Ahmed.
Yes, Mr. Baggett, just give me a second, because here's somebody who's not. No. Have you? Where's the little widget? No, somebody's taken away. Oh, no.
It'll be there.
Sorry. This is not switched on. This is not switched on. Sorry about this.
Not so.
Okay. We are cooking with gas. Sorry about that, Mr. Baggett.
May it please you, my lords, my lady, I appear, as you'll be aware, for all of the defendants, as I'll refer to them as in this appeal, with Ms Jones, my learned friends, Mr Weir QC and Ms Johnson appear for the Paul claimants, Mr Pitchers QC and Mr May for the Polmear claimants, and Mr Tyack QC and Ms Gamble for Mrs Purchase. I hope that you have available to you, whether in hard copy or electronic format, three sets of bundles. There's a core appeal bundle, which we've all referred to as A in our skeleton arguments. There's then a supplemental appeal bundle B.
I don't appear to have a supplemental bundle that I can probably find it.
Is my lord using the hard copy or the electronic?
No, I don't use paper, Mr. Baggett. But I'll get it.
We may not need to refer to it immediately.
No.
But there is B is a supplemental appeal bundle. We can assist with that if you don't have it available to you, I'm sure. And then C is the authorities, and there's one composite E bundle or 3 volumes if it's the hard copies. Can I begin by highlighting one point which I've made and we've made in the skeleton argument, which is that no one involved in this case could have anything other than complete sympathy for the claimants who suffered in tragic circumstances bereavements of their loved ones. Nothing that we say on this side about the legal principles limiting the scope of secondary victim claims is intended to diminish or underestimate their loss or the impact it's had on them and their families. Just to outline the structure of the submissions that I intend to make, and with your permission in due course, I'll ask Ms Jones to follow on. That is firstly to set the context, the practical context that we're dealing with here in these secondary victim cases, to take an overview look at secondary victim claims and how these cases fit within that spectrum, to look at the law in relation to the control mechanisms as they've developed.
Sorry, are these different headings, or is that all part of the what you're calling the practical context?
Separate headings, my lord.
So it was one was practical context, second was
overview of secondary victim cases. Yep. Then third heading, the law, and that would be subdivided into legal proximity and factual proximity, and space and time. and the event, its nature and consequences. Then we'll move on to the application of those principles to the particular cases and the grounds by reference to skeleton argument, but not stagedly following that, because you've obviously had that. And Miss Jones, say, with your leave, will follow on in relation to the application of those principles to the Polmear and purchase cases. I will deal with the application to the Paul case because it's intimately involved with the challenge to the judgment in that case.
What's the timing?
My Lord, we estimate 3 hours for the defendant's submissions or thereabouts. So going into this afternoon. In terms of the practical context, it's of course clinical negligence claims, but it's common ground between the parties that the same principles apply to secondary victim claims arising out of a road accident, a stadium disaster, a workplace accident, or, as we're concerned with here, clinical negligence claims. There are not different principles applying to each. In hospitals and other clinical settings, they are in a very particular position in relation to the potential for psychological responses by individuals due to the illness or injuries of loved ones, even before one comes on to the question of the secondary victim issues which arise. Because that's what hospitals and clinicians do on a day-to-day basis. People who are ill or vulnerable, not necessarily by reason of illness, of course, we have obstetric cases as well, go to seek their treatment, followed by their loved ones. Normally
You're
that...
saying hospitals, but I mean general practice. You mean doctors, don't you?
Yes, clinicians in the wider sense, absolutely. And obviously here we're concerned with that, any clinical setting. Normally that will be because of the illness or injury, or might be a condition that occurred elsewhere, whether that's actionable or not. Sometimes it's because of something that happens in that hospital or clinical setting and as a result of that. That will sometimes be actionable. There will be a primary victim who will be able to bring a claim. But the question, of course, then is whether the relatives will also have a claim. As the authorities discuss, the nature of the illness or injury to the primary victim in a hospital or clinical setting, if there is negligence, may well be different. So it may be of sudden onset, it may be a gradual deterioration or development, or there may be no overt symptoms at all. That's of course right, it's in the nature of things that those sort of considerations can arise outside the clinical setting. One can think of the example of long-tail disease claims against employers, such as mesothelioma, where there will be a long period of time with perhaps no symptoms, no awareness, and then a grave condition which may result in, will result in a gradual decline, sadly in the instance of that illness, almost inevitably to the person passing away. But those different settings and those different circumstances do not alter the requirements for secondary victim recovery, which apply across the board in whatever setting. So putting it bluntly, if the elements of sudden shock or proximity in space of time are absent because of the nature of the clinical negligence, an omission perhaps, then that will indeed make recovery that much harder. But this situation, this impact from the control mechanisms, is far from unique to clinical negligence cases. Other examples are discussed in the case law. The law excludes a claim by relatives even where there is negligence, where a primary victim's health gradually deteriorates after an accident, or where it deteriorates long after the negligent infliction of some damage which may be symptomless. In the words of Mrs. Justice Hallett, as she then was in White and Liddell, one of the cases before you, we don't need to go there right now. A distraught parent cannot sue for the progressive assaults on him or her caused by the despair in looking after a brain-damaged child. Sadly, not all those who suffer compensation can be compensated in damages. And it's in the nature of an effectively codified system. I use that in the broadest sense to just a description of the control mechanisms. I appreciate it's not a formal statutory code, but we have a codified system of hardline rules limiting the scope of claims on grounds which have been described long ago as arbitrary. Claims which may, outside the prism of secondary victim claims, may have equal merit, may engender significant sympathy, may have caused psychiatric injury, all arising as they do out of a human tragedy. Those claims will potentially fall just short of satisfying the conditions, or may fall well short and be unable to succeed, but they're no less, in the wider sense, on a human level, meritorious. I apologise for drinking from a bottle, but I think that's what we're supposed to do. It's in the nature, really for the reasons we advance in the skeleton and the grounds, we say that the decision of Justice Chamberlain in the Paul case, and of course the subsequent decision of Master Cook based upon it in the Polmear case, and obviously you've noticed that he was the same master who had originally decided the Paul case in favour of the defendants. In the light of the Paul decision, he then decided the Polmear case against the defendants, allowing that claim to proceed, not striking it out. And in the purchase decision, were this court to overturn the decision of the district judge striking it out. The impact of all of that is to extend the law in relation to secondary victims. In particular in the clinical negligence context, but not limited to that context by any means. We of course say that's an extension which is impermissible and goes well beyond the strict control mechanisms, and in any event that's a matter solely for Parliament under the authorities. And that's drilling down slightly because, as we submit, the first appeal succeeded absent the requisite physical proximity in space and time to a qualifying event. And therefore, as it's a necessary but not sufficient ingredient of it, absence the necessary legal proximity between the defendant and the alleged secondary victim. Putting it a slightly different way, there was properly analysed no duty of care owed by the defendants to the claimants. And it's crucial, we say, to focus on whether there's a duty of care, legal proximity, rather than identifying a particular event, which is tempting to do, and then seeking to trace back to the defendant's act or omission. And in the words of Lord Dyson, which again I won't take you to now, but we'll see later in Taylor and Novo, that's an approach which is apt to confuse that focus on the events rather than the essential focus on whether there's a duty of care.
Whether the events are a breach of duty or an event of damage.
Yes, one has to look at the...
So the event is really an irrelevant concept. What one is concerned with is the proximity of the claimant to the defendant.
Yes, both legal proximity as the umbrella term and physical...
There are two types of proximity.
Correct, of course, and physical proximity, which is an ingredient but not sufficient to establish the legal proximity. That has to be the absolute focus, and that's looking at the events is apt to distract, apt to cause the wrong answer to that question.
So you're really concerned with legal proximity because if the relevant event were the damage in the Paul case, then there would be plenty of proximity between the event and the secondary victim and the claimant.
Yes, that's the event. Yes.
But you're concerned with legal proximity between the claimant and the defendant.
Well, we are, but drilling down, because of the need to focus on physical proximity, because if you don't have physical proximity, you don't have legal proximity.
My Lord's point is there's plenty of physical proximity here to the, in case of Paul, to the death. That's not the problem.
Well, it's not. That's not the problem if that's the appropriate focus. If that's happening, that death is something which can be a qualifying event. If it can be, then of course, yes.
But that's my point. I mean, you say the focus on the event, whether it's the breach of duty or the damage caused later by the breach of duty, is the wrong focus.
Yes. And of course, you'll have seen I say that.
And that's what Lord Dyson said.
Sorry?
And that's what Lord Dyson said, properly analysed.
Correct, that's what we say. And of course, you'll have seen that our primary position is there was here no event at all, if one's looking at it from that perspective.
Well, there was an event. I mean, there was an event. There was a breach of duty and an event of damage, death.
Yes, but no qualifying event, so we should put it that way.
Well, I just think that the whole focus on events seems to me to be misplaced if Lord Dyson is A, right, and B, binding. I mean, I think it'll be said that he may not be right and he may not be binding, but I assume that would be on the basis that the binding case is Walters.
Well, that's, of course, what the claimants are saying here. That we've seen that we say that Taylor and Novo, Lord Dyson's findings there are indeed binding and indeed provide an answer to those questions.
And Walters is different because?
Well, A, it's a case not about proximity at all. It's a case about whether the shocking in law control mechanism was satisfied. So it doesn't deal with the point we're concerned with at all. Taylor and Novo is squarely a proximity case. It does absolutely deal with this question of whether you can look at later consequences. And also, I say, properly analysed, it's effectively a one-event case because the fit was the negligent infliction of damage. That was there was nothing earlier traced back to, so it doesn't support the suggestion you can have that long gap.
Right.
So all of those considerations about the difficulties with the decision and the impact of it are particularly important in the clinical context, but not limited to that, because a psychological reaction to a distressing event is unfortunately not an uncommon occurrence in a hospital or a clinical setting. The first appeal decision we say...
Well, I don't understand. I mean, most of these cases, the reaction occurs outside of the hospital. A classic failed diagnosis, whether at a hospital or at a GP level, the reaction we're concerned with happens later when, as a result of the failure to treat, the injury happens. So why is this point relevant?
It's relevant because, for instance, in Walters, that was a case where it happened in the hospital setting. There are cases where things do happen in the hospital setting.
Right, that's very unusual. Well, it's certainly not typical of these cases.
Not in these cases. It's not unusual in the sense that, putting it slightly crudely, bad things happen in hospital because people go there ill and sometimes get worse, not better, sometimes in shocking circumstances. So it's a regular occurrence that people see distressing things in hospital, and they're there because they're supporting their ill relatives.
But that is accepted in the authorities and doesn't give rise, generally, to any claims. Walters is a case on particular facts, and that was clear both by the judgment of then Lord Mr. Justice Thomas and by the Court of Appeal. And as my Lord the Vice President has said, generally the secondary victim cases are outside the hospital setting because it's accepted. Hard though it is on loved ones and friends that within that clinical setting there will be upset and there will be distress.
Yes. Well, it's a feature which is not part of these cases in these appeals, but there are plenty of cases litigated around whether that threshold is satisfied in the hospital.
There may be, but then, myself, I find you at the point you're making, focusing on the fact that bad things happen in hospital, a bit of a distraction, because none of these cases are of that kind. And the principle must be one that applies whether it happens in hospital or not.
Yes.
It may not even happen as a result of clinical negligence. Someone badly designs a bit of a building, you don't put an RSJ in a door and it's going to collapse sooner or later. It may happen months, years later. It's clearly a duty of care to the primary victim who is injured standing under it. We'd have exactly the same problems if their loved one was just a few paces away and saw it all happen. So I don't think it's helpful, particularly, to emphasise that this is all in a clinical context.
No, well, I think the point I'm making is that because people have some condition or are often ill when they're seeing someone in a clinical setting, that is an area which commonly gives rise to these sorts of questions, because it could be something in hospital, it could be something out of hospital if they're then discharged.
But all that's got absolutely nothing to do with it. We have to decide the legal principle. And my Lord's example is quite a good one. If somebody negligently designs a building so that the RSJ is teetering on the brink of collapse for 10 years, say 5 years to avoid limitation problems, and claimant A stands under the RSJ and it collapses on claimant A's head. Claimant B is a close relative who's watching and is incredibly distressed, as they would be. The question is, does claimant B have a claim? And the answer depends on whether there is proximity between the architect who designed the defective RCJ, whatever it's called, the defective beam, and the claimant B. And you have to say that the answer to that is no, however proximate the claimant B was to the event, because there is no proximity between the architect and claimant B.
Correct.
And that's an arbitrary rule that you say is actually nothing to do with the control mechanisms. It's an arbitrary rule that has been laid down by the House of Lords, and it's been said that it can't be changed except by Parliament. And it is consistent with Lord Dyson, but possibly not with Walters.
Correct. But I would urge caution about those sort of examples, in the sense that there's no involvement of the primary victim until something happens. Whereas when one was looking at the clinical setting, if some treatment is given or not given, one is immediately concerned with something being done to or not done to the primary victim.
Why does that make any difference? There is no involvement with the primary. There is no involvement with the primary victim. But why does that make any difference?
Because if one's looking at the starting point, as it were, for the tort of the primary victim, that's when something happens to the primary victim, something is done to them. In those examples, once something is done to something else, and then the primary victim later is involved in the infliction of a tort. So there is already a gap, so one has to be careful about, I would submit, using that sort of example and transferring it to these cases where you've got someone who is in hospital, being discharged, being treated, having some treatment given to them or not given to them. So the primary victim is squarely there at that moment, and then one's looking at that, can you trace from there a sufficient nexus? So it's a slightly different situation.
Yes, but slightly different situations are the reason why we have to have a coherent legal position, because people must understand their rights. And I don't really understand what you seem to be saying that events are relevant. In other words, the event, which is the negligent advice, is relevant to the question of whether there is liability to what I've called C2.
Well, one has to look at what actually happened, of course, when one's trying to answer these questions. But I shouldn't have used the word slightly. They are different situations because the primary victim is not involved at all until there's actually a tort to the primary victim. That's later down in the process when there is the collapse of the ceiling or...
Well, I don't know. When you say a tort to the primary victim, is that right?
It's just damage.
There's a breach of the duty of care by the architect at the moment that they specify the wrong beam, example we're going with, and just as there is when the patient is sent away and told you're fine. There's a breach of duty of care in both cases at the same point, and the victim only suffers harm days, weeks, years later. I know there's been in the case law, not perhaps in the case law, in the skeleton, some discussion of fancy points about the point at which the patient begins to suffer some sort of injury which doesn't manifest itself. But in a pure example, that might not happen even in a clinical setting. The doctor prescribes the wrong medicine. No harm done then, but a week later after he's been to the chemist and had the medicine and takes it, harm done at that point.
Yes.
But the breach of duty will be at the prescription level.
Yes, well, one's looking for the point at which there is some completed tort, some
Well,
actual...
is one? Why?
Why? That's the whole point. I don't understand why you say that. I mean, that is what is bedeviling this argument. All this stuff about completed torts. There's nothing in the House of Lords authorities about completed torts.
Well, we say there is because it's the fact and consequence of the negligence. That's what's described.
Yes.
And so one's looking at, and I'll say in due course that Lord Dyson focuses on this, one's looking at the point at which there is some impact on the primary victim to complete the tort, some actionable harm.
So when, going back to McLaughlin, and Lord Wilberforce refers to the facts and consequences of the negligence, are you saying it is when the consequence arises, that is, the completed tort?
Yes, so in the Taylor and Novo case Lord Dyson was dealing with, he said that that was the point at which the racking boards fell over and there was some impact on the primary victim. What we say is there's an unprincipled distinction being made here between cases where the impact is somehow silent or symptomless or hidden, because that's what the claimants have to argue, because if they're arguing that it's the situation is you can have some actual impact that's known and evident, that runs into the immovable object of Taylor and Novo, the decision in that case. So they have to argue when one's looking at a condition which is hidden, not yet evident, nothing to see, symptomless, the situation is different.
But that wasn't the decision in Taylor and Novo. I mean, all that is quite. I mean, there's some discussion in Taylor and Novo about that. But the decision in Taylor and Novo is that there was no legal proximity between the claimant and the defendant. Because the defendant was 3 weeks, the claimant, who is C2, the secondary claimant, had nothing to do with either the stacking of the shelves or the person who was negligent, Novo, at all and was 3 weeks removed from it. So there was a lack of legal proximity. That's the ratio of Taylor and Novo, which is nothing to do with events. There are two types of proximity, and they are thoroughly confused, and they shouldn't be. The proximity that you're talking about is one of the control mechanisms, and that wasn't what Taylor and Novo was about. There was simply no connection between the claimant and the defendant. And anyways, it seems to me at the moment, the point is that you have to say that that's the same here. Anyway, in Paul, we can discuss the other cases.
Yes.
And if you don't say that, then I don't understand what you are saying.
Yes, but in Taylor and Novo, the reason there was no legal proximity is because there was no factual proximity, because Ms. Taylor, the claimant, was not in any sense physically proximate to the accident at work when the first consequence happened.
It's to do with the proximity between the claimant and the defendant.
My lord, yes, but the reason there was no proximity between the claimant and the defendant was because there wasn't the necessary ingredient of that legal proximity, which was factual proximity to the relevant event. And Lord Dyson said to try and...
What is the relevant event?
There was the...
Is it the breach of duty or is it the accident?
It was the first consequence. It was the racking boards falling and causing the initial injury.
First consequence? This all sounds very...
Exactly.
metal.
You've got to read, we've got to look at Taylor and Novo, because everybody concentrates on the two reasons that Lord Dyson gave. That the ratio is not found in those reasons. It's found in the preceding 3 paragraphs.
Well,
We're going to have to look at it.
of course we are, my lord, yes.
And that's where everything's gone wrong. Everybody's obsessed with events. But these cases are not about actually events, except insofar as the control mechanism is concerned.
Well, that is part of answering that legal proximity question. I think we probably all agree about that. One has to look at that, but it has to be done with care, as Lord Dyson says, not to distract from the essential question, which is, as my lord rightly highlights and stresses, is there a legal duty of care at all? But in answering that, the only way to answer that in a secondary victim case is to look at, are the control mechanisms satisfied, or it's part of that process?
Okay. Anyway, you take your course.
So I was talking about the outcome of the appeal. Excuse me. As you'll have seen, we say that's contrary to previous High Court and Court of Appeal authority. We also say that the judge didn't grapple with the question of fairness between claimants, classes of claimants, which the authorities, both House of Lords level and Court of Appeal level, have stressed is critical here. Between those who are shocked by consequences long periods of time later, and those who come on the immediate or first consequence, but are shocked by a scene which, perhaps only just, is outside the immediate aftermath. So the latter cohort not having a claim, and the former having a claim, and Lord Dyson was at pains to highlight that that would be unfair, and that unfairness is a critical consideration in this arena of secondary victim claim, because for the very reason that there are already arbitrary boundaries, there needs to be fairness between those who pass that threshold. And it also creates an imbalance, we say, because the decision creates a more benevolent approach to the question of the control mechanism for physical proximity when authority says that they should all be applied strictly. And we say it also creates an incoherence in the law of tort, because it's applying a different test, applying a test of the first manifestation of injury to secondary victim claims as compared to the long established and recently confirmed threshold of actionable injury, something different which can be symptomless and hidden, applicable to all forms of other injury claim. And just to pause and observe at that point, it would seem strange if a more benevolent approach is to be taken to that threshold in a class of claims, secondary victim claims, which are exceptional claims and which are to be limited by arbitrary boundaries, as compared to the mainstream of injury claims to primary victims, which are not subject to those same strictures.
I'm sorry, I've been slow. What is the less benevolent approach being taken in the case of primary victims?
If you allow the threshold in a secondary victim claim, you can still bring that claim if you're proximate to the first observable or evident or manifest injury to the primary victim. That's something which is later down the line. That's easier to satisfy than the relevant test for other injury claims, which would be the actionable injury is when some more than de minimis harm is caused. Whereas, so that the mainstream injury claims, which don't have any of the control mechanisms controlling them, has a...
They're more benevolent in limitation terms.
Well, more benevolent in the test of when the cause of action...
But when the cause of action arises, is any relevant limitation, isn't it?
Well, it's relevant to secondary victim claims if it allows people to bring claims at a later point when symptoms first become evident, rather than...
Well, this is illogical, isn't it? Because the secondary victim can only bring a claim when they have suffered an injury. And the fact that the primary victim may have suffered some injury beforehand is a different question.
Well, it's relevant to physical proximity, because you have to be proximate to the fact and consequence of the defendant's negligence. And we say that is at a previous point. That's the point at which there's actionable damage, not the point at which that becomes manifest. That's later. And can I turn to look at an overview of secondary victim cases and to explore some of the concepts that we've been discussing a little further. There's an interrelationship in tort of the rules relating to duty, causation, foreseeability and proximity, and they're of course very familiar concepts. But it's important, we say, for this appeal to be clear as to how that interrelationship has developed as applicable to primary victims and secondary victims. There's the familiar distinction between the two, the primary victim who suffers injury, whether that's physical or psychiatric, directly as a result of the tort, the road accident, the stadium disaster, incident at work, clinical negligence, whatever it may be, and the secondary victim who of course suffers that psychiatric injury as a result of being exposed to the actual or perceived danger to others. So in each case, primary and secondary victim, the same rules as to duty, causation, foreseeability and proximity apply, but the distinction between them is as to how the law determines the question of legal proximity, whether there's a duty owed to the secondary victim. So in relation to secondary victims, that question is harder to decide as a matter of, if you like, common sense, or appeals to logic, or a Paro type approach. And for that reason, the law has developed a number of hardline tests, control mechanisms, looking at different aspects of the claim to determine whether it can be successful. over and above those other considerations. So, of course, the nature of the relationship between the primary and secondary victim, the nature of the secondary victim's experience of the threat and injury to the primary victim, the physical and temporal proximity of the secondary victim to that experience, and the requirements of shock. There has to be a threshold shock, a sudden, unexpected and horrifying shock, and that shock, as opposed to some other part of the experience, caused the psychiatric injury to the secondary victim. It's important to put those developments in their proper context. Because one can posit as a matter of theory a range of different types of tort system, and to place this system in that spectrum. So leaving aside the question of no-fault compensation, which strictly speaking isn't a tort system anyway, since there isn't a wrong, you could have a number of different systems. Firstly, a system where if the defendant commits a negligent act or omission, then that defendant is liable for all the consequences to anyone, whatever sort flow from it, whether it's physical, whether it's psychological injury, or economic loss. So that's another question. And in such a system as that, the only question would be causation. That would be all that needed to be proven. There'd be no requirement for any form of foreseeability or proximity, so no need for a duty to the particular individual. And of course, we don't have that system. The second possibility is if the defendant commits a negligent act or omission, then it's only liable for the consequences that are reasonably foreseeable. So in such a system, causation and foreseeability are all that need to be proven, and there's no requirement to prove a specific degree of proximity or duty. Then you can have a third system requiring, as well as those considerations of causation and foreseeability, also some element of proximity. So a basis for saying the victim, whatever the circumstances of his or her injury, should have been within the defendant's contemplation at the time of the tort. So Lord Atkin's neighbour principle, but that system would still not have any distinction between primary and secondary victims. So that's closer to where we are, and that's what was urged on the House of Lords by the claimants in the Whitecross Hillsborough litigation by the police officers, but the House of Lords rejected it. Fourthly, a more restrictive system than the one we have would be one where no secondary victim claims can be brought at all. Some academics have called for that as an answer to the present situation. That would require proof of all of causation, foreseeability and proximity in the primary sense only, and that was what was urged on the House of Lords by the defendants in the White case, and they rejected that as well. So our system is positioned between those last two scenarios. Causation, foreseeability and proximity are required. The proximity requirement is as per Lord Atkin and Donahue and Stevenson. From proximity is relatively easy to establish in a primary victim case, whether that's a road accident or an accident at work or clinical negligence. But looking at secondary victim jurisprudence, this represents something of a historical anomaly, on one view at least an illogical one, in that, and it's an extension to the normal proximity rules, so as to allow recovery in extreme cases.
Why is it an exception to the normal proximity rules?
Because normally there is no duty to someone who is impacted only by reason of their relationship with the victim of a tort.
But it's a rather tendentious way of putting it, because you've got to decide what the proximity rules are in the first place.
Yes, but it's a claim which doesn't rely on any direct impact on the secondary victim from the initial tort. So, for obvious reasons, it's less easy without special rules to identify in what circumstances there's going to be legal proximity to a secondary victim where the circumstances are more open-ended. So if we take a road accident, what about the onlooker who sees it and suffers psychiatric injury but is unrelated? Or the family member who is shocked but wasn't present? Or in clinical negligence, what about negligent acts and omission which result in no shocking event, albeit the parents say they are shocked and they sustain psychiatric injury? So hence we have the development of the special rules, the control mechanisms to decide on whether legal proximity between the claimant, secondary victim and the defendant, which by definition and self-evidently shuts out from recovery those who may have suffered genuine psychiatric damage. And it's in this context the requirement to be considered in this case as to the other meaning of proximity other than the umbrella legal term arises, which is proximity in space and time to the happening. But as I've said, the function of these control mechanisms in secondary victim cases is to establish legal proximity. Absent any single one of them, there is no legal proximity between the defendant and the secondary victim, and as my Lord the Master of the Rolls observed, no duty of care on the tortfeasor in relation to the secondary victim can arise. Taylor and Novo is the latest in the line of authority on the topic of factual proximity to answer the question of legal proximity. And it confirms that by these means, by those control mechanisms of legal proximity to the victim, to the event if there is one, and thereby ultimately, and that's what really matters, looking at the connection, the nexus to the tortfeasor. So many of the control mechanisms relate to the relationship between the primary victim and the secondary victim, so we've got close ties of love and affection, or relate to the connection between the secondary victim and the happenings, so physical proximity to a relevant happening in space and time, or direct perception of its immediate aftermath. Some of them relate to the nature of the happening, the event itself, and the direct effect on the secondary victim that has had. So the need for it to be sudden and shocking in nature, objectively viewed, and that it has to have been that which caused the psychiatric damage to the secondary victim. So at the heart of the appeal is of course legal proximity, but going below that is physical proximity and how that's to be applied in clinical negligence omission cases, but because one's dealing with the same rules applying everywhere to secondary victim claims more widely, where there's a gap between the defendant's act or omission, the completed tort, and its consequences, whether that's a few days, whether that's some hours, whether that's some months, or whether it's more than a year.
Well, we're back on events again. I mean, you're going to show us where Mr. Justice Chamberlain went wrong on your submission.
My Lord, yes.
I mean, I'm conscious of the time.
Yes.
You've given yourselves 3 hours together, and we haven't looked at one case or the judgment below yet.
Lord, yes. Can I turn to the facts of the Paul case, just to touch on those? If you
Well, we've looked at those, but yes.
So, it might be helpful to look at the supplementary appeal bundle and the particulars of claim. And my Lord Master Rolls
I've got it,
some
yeah.
difficulty locating that.
No, I've got it now.
So, at B5, paragraph 11,
Which page in the...
will be page 6 of the PDF. I apologise if they're not sequential. Paragraph 11.
Sorry, I'm using the hard copy.
Yes,
Which tab?
Page
2.
Tab 2. Thank you. Page 5. Yes, I have it. Thank you.
yes, particulars of claim in the full case.
Yep.
So that's the background. Mrs. Paul had type 2 diabetes for about 20 years. He'd suffered various complications, various other health conditions. One goes on to the following page, paragraph 20. He was admitted to hospital with emergency complaining of chest pain in November 2012. Various investigations were carried out, but not an angiogram, which is what's criticised by the claimants. So he underwent various other tests, including at paragraph 26, an ECG, but there were no significant changes noted on that. The claimants say at paragraph 27 that this was mildly positive, low workload, and virtually diagnostic of underlying coronary disease. He was discharged and underwent as an outpatient further tests, but those didn't produce angina symptoms at paragraph 28, final 2 lines, and medical treatment was recommended. This renal condition continued to decline, and we see through the following paragraphs that paragraph 32, dialysis was commenced. Then paragraph 34, he was admitted to hospital in August 2013 as an emergency with a 2 to 3 week history of breathlessness, and he was then moved on to hospital hemodialysis. Renal transplantation was discussed, and paragraph 35 at the turn of the page on...
Sorry, it would help me to know what point we're getting at all this detail.
Yes, I'm setting out the chronology of the declining symptoms, and that prior to Mr. Paul's death, he'd been referred back to have the very...
So is the point you're trying to get out of this that he had had symptoms between the alleged breach of duty and the
Yes.
death?
And although it's pleaded that the event, the death, was the first manifestation of the breach of duty, claimants in their skeleton argument accept that the primary victim had experienced actionable damage prior to January 2014, and they have to do that, of course, because otherwise it wouldn't be a case on causation. They say he would have undergone treatment prior to January 2014 to address his heart condition, putting him in a better condition to avoid the heart attack and death. They have to do that to avoid summary judgment in terms of causation, but they accept that there's actionable damage prior to that point.
But no manifestation of it they are relying on.
Yes, they're relying on the first
Yes.
overt symptom, correct, my lady?
And that is what the judge did.
Correct. I'm conscious that you will have looked at the House of Lords cases. I don't propose to take you through those in any detail. But can I just take you to a few features of the McLaughlin case, first of all, looking at the law. If you have the authorities bundle C, this is page 30 is where the report starts, and I'm pleased to say in this bundle the page numbering is the same in the e-bundle and the hard copy. Tab 2. facts are well known, but worth reminding ourselves of, that it was a road accident involving the claimant's family. She wasn't present at the scene, but she learned about the accident and was taken to the hospital, arriving around about 2 hours after the accident, and saw her family members in different stages of distress and treatment, and was told about the death of one of her children. And the question was whether she could recover, of course, by being not present at the scene or seeing that scene, but coming to the hospital. Page 39 of that report at F.
Page 39.
Yes.
Yeah.
Sorry. The observation, which is an important one, is being made by Lord Wilberforce about rationalising whether to allow the claim to pass the threshold, is whether it could make any difference that the person comes upon the loved one in an ambulance or here in a nearby hospital when the evidence shows they were in the same condition, covered with oil and mud and distraught with pain. So there's a close connection. I won't take you to it right now, but in the Ronayne case, a much more recent Court of Appeal case concerned with shock, the court observed that the proper explanation for McLaughlin was really that this was the scene of the accident transposed into the hospital setting. So it was something akin to seeing the scene of the accident because the relatives were covered in mud and oil and distraught with pain. Moving on to page 42. D, this is where Lord Wilberforce deals with the requirement of physical proximity. Says it's obvious it must be close in both space and time, and this is where he has his classic formulation. It's, after all, the fact and consequence of the defendant's negligence that must be proved to have caused the nervous shock.
No, when?
42 at D, my lord.
D, thank you. Yeah.
So, the important observation here, I'm not suggesting this is a statute, but the use of words is important. What we're not concerned with is the fact or consequence. We're concerned with the fact and consequence. And we're not concerned with a fact and consequence. We say it's important when looking at physical proximity that you look at those twin elements, the fact and consequence, i.e. what's resulted from it, not looking at one or the other. And that's what we say that the claimants here in the decision of the judge does, because it effectively means you can look at a consequence alone rather than the fact.
I don't understand that. There will always be the fact of negligence.
The fact of negligence is the tort, we say.
Well, it might be the breach of duty. It's not clear in what sense. People often talk about negligence, even in the House of Lords, meaning breach of duty.
Yes.
Not necessarily the fully completed tort. The issue didn't matter in that case.
But here, on any view, it's not. It's a later consequence, which Lord Dyson says in our submission is an impermissible approach. You look at the later consequence when it becomes evidence. You're looking for the fact and consequence when you're trying to say, is this proximate in space and time to the defendant's negligence?
So can I just dealing with the facts of Paul, are you accepting that the heart attack which caused his death was in fact a consequence of the negligence?
Yes, that's well, negligence is an issue in the case, but obviously the assumption is on the application that's established. So yes, it's a consequence under that, but is it something which is a consequence which can be looked at in terms of there being a duty of care here? Can you look at the first point being the first manifestation, the first overt consequence, or do you have to trace back to where the first actionable harm is, which is accepted?
Yes, but
prior
there's
to
nothing
that
about
offence?
any of that here, understandably, because the issue never arose. It's a classic car crash. The negligence happens split seconds before the first injury, and generally in a car crash, the first injury is really all just one injury.
Yes, but what we say is if you're looking at the specific focus is on, is it close in space and time to the defendant's negligence, then you shouldn't be looking at a point which is well beyond where negligence is established.
Well, it says proximity, it says the accident, not the negligence.
Well, the fact and consequence of the defendant's negligence must be proved to have been the cause of a nervous shock. So it's linking those concepts together.
Well, I mean, speaking for myself, this is in a way an important passage, of course it is, but you can only get so much out of it because Lord Wilberforce was not looking at the particular kind of problem we have here.
Correct, and part of the reason I'm stressing it is because here we were 2 hours after the tort, effectively, and the court, as we'll go on to show, said that this was at the extremes of what could be permitted. So that's what we say is the context of all of that. Further down that page at H, on the same page, subject to those qualifications, a strict test of proximity by sight and hearing should be applied by the court. So the aftermath extension is a limited one to bring into the class of persons who can claim someone who hasn't seen the actual injury or peril to the primary victim, but has come on to a scene so soon afterwards that they've effectively seen that scene. They can imagine the scene they've seen, in this case, the mud and oil on the victims. Sorry, my lord's one other point I wanted to. Apologies for taking you backwards, but can I take you back to page 39, because there was one other passage I should have mentioned there at G. And there what was said was to allow the claim in these circumstances 2 hours after the tort was at the margin of the process of logical progression, where the facts are strong and exceptional.
Sorry, where did I find about the 2 hours?
Sorry, the 2 hours is not mentioned here.
I see, that was you.
Apologise, that was me.
Okay, got it.
I should read it properly. To allow her claim, maybe, I think it is, on the margin of what the process of logical progression would allow, but where the facts are strong and exceptional, and as I think fairly analogous, her case ought prima facie to be assimilated to those which have passed the test. So it was stressing, we say, the outer limits of the aftermath exception, and you apply the tests unless you come within that strong and exceptional situation. Can I move on to observations on Alcock? Of course, the unsuccessful claims by the relatives of the Hillsborough victims, some were in other parts of the football ground, one was just outside the ground, some were watching on television. Page 87 of the bundle. This is part of the judgment of Justice Hidden, so not the House of Lords, but Justice Hidden, who considered the trial at first instance on assumed facts. And here at D to E was considering whether there's an entitlement to extend recovery And if you're going to do so, you have to consider three elements which are ripe for extension. Firstly, the relationship between the plaintiff and the original victim of the negligence, the loved one. Secondly, the relationship in time and space between the plaintiff and the scene of the original negligence. And thirdly, the medium through which the plaintiff becomes conscious of the original negligence. It's just interesting that Mr. Justice Hidden is focusing back on the original negligence rather than some later consequence of it. Moving then straight to the judgment of Lord Ackner at 154, please.
So, how many judgments were there? Were they unanimous?
There was effectively 5 judges. Lord Lowry agreed with the other judges, and Lord Jauncey's judgment was brief. The principal judgments were those of the first 3 judges, Lord Keith, Lord Ackner and Lord Oliver.
And do they agree with each other?
Yes, they did. I can take you to the head note and the holdings, if that would be of assistance. At
Well,
page.
it could be said, couldn't it, that they agree as to the outcome. They don't, tell me if I'm wrong, they don't explicitly agree with each other's judgments, so it could be said they take different routes to the same result.
Yes, that'd be a fair observation, and it's a different era perhaps when it's more common for individual speeches to have been given.
Well, Lord Oliver is often cited as laying down principles. Is there any suggestion in this case that that's wrong?
No.
No. Okay. Anyway, Lord Ackner at 154.
At E on that page, Lord Ackner makes the point towards the bottom of that paragraph. There's a line saying the following propositions illustrate that the application and simplicity of the reasonable foreseeability test is today far from being operative. So just making the point that that alone is not enough. It's a more restricted test than that. Then moving on to 155, please. That's just above G, where there's discussion of the requirement for shock and what that has to look like. I don't find it surprising that in this particular area of tort that the negligence, the reasonable foreseeability test is not given a free rein. Then dealing with proximity, the specific question we're concerned with at 158H. Second sentence, direct and immediate sight or hearing of the accident is not required. It's reasonably foreseeable that injury by shock will be caused to a plaintiff not only through sight or hearing of the event, but its immediate aftermath. So confirming really what was decided in McLaughlin. Then moving on to the, my Lord Master of the Rolls highlights the principal speech given by Lord Oliver, so 160G please. Five lines up from the bottom. In essence, this involves answering the twin questions of A, whether injury of this sort to each particular plaintiff was a reasonably foreseeable consequence of the acts or omissions constituting the breach of duty of the primary victim, and B, whether there existed between the defendant and each plaintiff that degree of directness or proximity necessary to establish liability. So really making the point that these are twin but separate questions. 163 G to H.
Can I just ask you a question that's been troubling me? There have recently been 2 or 3 very important decisions on negligence in the Supreme Court, which I don't see in any of the bundles. I take it that nobody before us says that those cases affect the tests that have been adumbrated by the House of Lords in the cases we're looking at.
Well, for my part, I don't say that they do, and I'm not aware that others are seeking to rely on those cases, no.
Right, but they have been properly looked at, I'm assuming.
Yes, thoughts are
Okay,
given to it.
all right. Sorry, I interrupted you.
Not at all, my lord.
Okay, we've got twin questions here.
Yes, 163 at H, if you have that.
163, yeah.
So really providing the limit on claims. Beyond this, however, the law in general provides no revenue, however severe the consequence of the distress or grief, maybe to the health or well-being of the third party, and however close the relationship to the victim. Then Lord Oliver goes on to consider possible reasons for this. The next sentence says, of some significance, I doubt whether the reason for this can be found by an appeal to logic, because there is a theme running through the skeleton arguments for the claimants that one has to resort to some sort of logic or common sense, or that's difficult to do in secondary victim claims when one's applying arbitrary rules. There will always be people who fall the wrong side of the line, who's on a human level, their claims seem no less meritorious. Then 4 or 5 lines down, Lord Oliver excludes another reason for the limitation, saying, cannot, I think, be accounted for by saying that consequences cannot reasonably be foreseen. Then going further down, just 2 lines above D, that simple test of foresight, that is, simple test described by Lord Atkin in the classical exposition in Donahue and Stevenson as demonstrably too wide, and refined by him into the more restricted neighbour test, which introduced, in addition to the element of reasonable foreseeability, the essential but elusive concept of proximity or directness. Then Lord Oliver goes on, if we move down beyond E towards F and G.
Which page?
Same page, my lord. Just below F.
Which page? Number?
It's 164.
Thank you.
So just 2 lines below F. Must, as it seems to me, be attributable simply to the fact that such persons are not in contemplation of law in a relationship of sufficient proximity or directness with the tortfeasor as to give rise to a duty of care. No doubt policy, if that's the right word, or more properly, the impracticability and unreasonableness of entertaining claims to the ultimate limits of the consequence of human activity necessarily plays a part in the court's perception of what's sufficiently proximate. Then, in the next paragraph, Lord Oliver goes on to consider why this anomaly or exception has arisen in these sort of cases. So what's more difficult to account for is why, when the law in general declines to extend the area of compensation to those whose injury arises only from the circumstance of their relationship to the primary victim, an exception has arisen in cases in which the event to the primary victim has actually been witnessed by the plaintiff and the injury is established as stemming from that fact. That such an exception exists is now too well established to be called into question. What is less clear is the ambit of the duty in such cases, or to put it another way, moving on to the next page, what the essential characteristic of such cases that marks them out. Next paragraph, top of just first main paragraph on page 165. Although it's convenient to describe the plaintiff in such a case as a secondary victim, that description must not be permitted to obscure the absolute essentiality of establishing a duty owed by the defendant directly to them, a duty that depends not only on the reasonable foreseeability of damage of the type which has in fact occurred to the particular plaintiff, but also on the proximity or directness of the relationship between the plaintiff and defendant. So that's the point that we were highlighting and discussing earlier about the importance of looking for the duty of care. On that same page 165, further down, just above F, and this is the classic paragraph where Lord Oliver sets out the control mechanisms effectively. I'm not going to read it out, my Lord, but that's from just above F, moving down. If we go down to just above G, the third
Sorry, which page are you on again?
165, just above G, my Lord.
Yeah.
2 lines above that. Thirdly, the plaintiff in each case was either personally present at the scene of the accident or was in the more or less immediate vicinity and witnessed the aftermath shortly afterwards. And then Lord Oliver sets out all the other considerations. Then just at H on the same page, there's a sentence starting, "It must, I think, from these elements, the essential requirement of proximity is to be deduced, to which has to be added the reasonable foreseeability on the part of the defendant that in that combination of circumstances there was a real risk of injury of the type sustained by the particular plaintiff as a result of his or her concern for the primary victim." And then going over the page, there may indeed be no primary victim. In fact, for instance, readily conceivable that a parent may suffer injury, whether physical or psychiatric, as a result of witnessing a negligent act, which places his or her child in extreme jeopardy, but which from the event, in the event the child escapes unharmed. One then goes on to 170, please. Again, Lord Oliver's making the point, just below D, that in every case, the underlying and essential postulate is a relationship of proximity between plaintiff and defendant, and that must be the determining factor in the instant appeals. It makes the point there's no case prior to the case before Justice Hidden where an award's been countenanced for injuries where there wasn't at the same time the degree of, and just at E on that page, degree of physical propinquity between the plaintiff and the event caused by the defendant's breach of duty to the primary victim, nor where the shock sustained was not either contemporaneous with the event or separated from it.
But that is exactly what happened in the case of Paul, wasn't there? There was a degree of physical propinquity between the plaintiff and the event caused by the defendant's breach of duty, namely the father's heart attack.
Well, the question is whether that, if one's looking at it from that perspective, whether it was a qualifying event.
Yes, but that... What, perhaps I'm only making a point I've made before, you can mine these very general statements, some of which, because of the particular way they're phrased, help one side, some help the other. But they only take you so far because they were not considering the distinction, the kind of situation which we have in this case, where the breach of duty, the negligence, were separated by a very long period of time from the event which caused the injury. Let's say the injury to the secondary victim.
Yes.
So I'm pleased to see all this. If I may say so, Lord Oliver's analysis is extremely careful and thoughtful and principled, but it wasn't actually ultimately being applied to a case of the present kind. So it gives you the tools in which to answer the question, but it doesn't help answer it particularly.
My Lord, no, but of course those are the tools that we have and we have to try and apply in this case, but I would agree it's not concerned with...
But I mean, for what it is worth, in case this point is taken against you, do you accept that the formulation at 416E is contrary to the submission you're making to us?
Well, no,
Because he appears to be saying that what you've got to have is a degree of physical propinquity between the secondary claimant and the event caused by the event caused by the defendant's breach of injury, breach of duty, and in cases of this kind, that is the death. Isn't it?
Well, that's an event, but is it the event? It's not saying the events or an event.
But
It's
it
saying
is the event which caused the injury to the secondary victim. That's
Yes.
why it's the event.
Well, it's not the event caused by the defendant's breach of duty to the primary victim. That's when he has a completed tort and he sustains some damage, which is accepted as prior to his death.
Okay, thank you.
You would probably say that's actually not part of what his statement of principle is. Statement of principle is about the proximity between the claimant and the defendant. The question of the proximity of the events is part of the control mechanism, which is a different question, as Lord Dyson pointed out. Completely different question.
Yes, two separate things.
Yeah, which is why
One
events are not what this is about. I mean, the confusion here is caused by this focus on events. Of course, there are, in every case, a breach of duty and an event of damage, and they are separated in time. But the proximity question, the legal proximity question, is not about the question of the relationship between the events and the secondary claimant. It's between the defendant and the secondary claimant.
Absolutely, it is, my lord, but it's answered in part by answering the question about physical proximity.
Well, you say that.
Well, it's one of the control mechanisms for answering that question.
You're confusing control mechanisms with legal proximity. I mean, the control mechanisms are set out. You didn't read them, but they're quite clear.
I think we may be driving at the same point, my lord, but the point I'm making is that in secondary victim cases, to answer the question, is there legal proximity, there are additional requirements, which are the control mechanisms. So absent any of those, you don't have legal proximity, i.e. you need those control mechanisms all to be in place, including physical proximity, in order to answer the question, is there legal proximity?
Yeah, what I'm putting to you is that is not the complete question. That actually legal proximity is required in every case, not just a secondary victim case.
I completely agree with
And
that.
the problem is the control mechanisms which introduce arbitrary restrictions on duty of care. But this case concerns whether there is a duty of care at all. In other words, whether, I mean, in the old language, the victim is within the contemplation of the defendant. And the defendant, in a case of this kind, if it were a road accident, it's easy. Because if you are negligent on a road and you cause death, it's entirely foreseeable and instantaneous that somebody seeing it is going to be within your contemplation as being proximate, sufficiently proximate. It's quite different if you're a doctor giving advice to a patient whose damage occurs a year later. The fact that there may be such damage is certainly foreseeable and likely, but the law has said that people watching it are not sufficiently proximate.
I wonder whether is this what you're saying, that although from one mega point of view, policy point of view, one can call them control mechanisms, that may not actually be the most helpful way of characterizing them for our analysis, what Lord Oliver is really saying is reasonable foreseeability is not a problem in any of these cases. The real problem is you need also proximity, or directness, he calls it either, but this ourselves just call it proximity, which is a legal concept. And that legal proximity will only exist between the tortfeasor and a secondary victim if a number of rather restrictive conditions are satisfied, which are what is elsewhere called the control mechanisms. They are control mechanisms if you see them as limiting reasonable foreseeability. Another way of looking at them is that they are the requirements of proximity, the relationship of proximity, in this particular class of case. And Justice Hidden, I think, characterised them under 3 heads, Lord Oliver under 5, but they're actually just slightly more refined version of the same points. Is that where there's a possible misunderstanding between the way my Lord's putting it to you and the way you're resisting it or putting it back?
I think that is, yes. Yeah.
Well, I'm not sure anyway, just to pick off one thing, that Mr. Justice Hidden was saying the same thing as Lord Oliver at all. I don't think those 3 propositions that Mr. Justice Hidden that we took us to were at all the same as the 5 control mechanisms set out by Lord Oliver.
He was looking at a
I'll
slightly
accept correction on that, but we can stick with Lord Oliver, we don't need Mr. Justice Hidden.
Yes. If convenient, I was going to take you to page 171 at D.
(171E).
D, please, just below D, 4 lines below D. Here the court was looking at whether television images would be enough to provide the necessary shock and answer the question of proximity or visual identification of a victim after the event. And there's a line starting, the trauma is created in part by such confirmation, in part by the linking in the mind of the plaintiff that confirmation to the previously absorbed image. To extend the notion of proximity in cases of immediately created nervous shock, this more elongated and to some extent retrospective process may seem a logical analogical development. As I shall endeavour to show, the law in this area is not wholly logical, and whilst having every sympathy with the plaintiffs, whose suffering is not in doubt and is not to be underrated, I cannot for my part see any pressing reason of policy for taking this further step along a road which must ultimately lead to virtually limitless liability. And then a few lines below that, please, at F, 2 lines below F. I equally believe that further pragmatic extensions of the accepted concepts of what constitutes proximity must be approached with the greatest caution. And then in the rest of that paragraph, Lord Oliver goes on to make the point, last 3 lines. Any further extension or widening of the potential liability should be undertaken by Parliament.
Right.
Can I move on to White at tab 7, please?
All right, can I just summarise this
Yes.
so that I properly understand what you're saying, Mr. Raddick? Given now we've looked at what might be called the 2 real lead cases into this whole concept, what principles are you deriving from them?
That the control mechanisms are additional restrictions on secondary victim claims beyond primary victim claims. Those are an exceptional category of claim where the law does not normally allow recovery. But the essential focus is on, is there a duty of care at all? Legal proximity. But in answering that question, one looks at a series of control mechanisms, which include the question of physical proximity
to the fact and consequence of the defendant's negligence. And that any attempt to do that by some sort of retrospective process or to extend it beyond the existing principles, which are already exceptional, is to be resisted and only done with the greatest of caution.
You see, I mean, if that's your submission, then surely you lose. Because in your case, Paul, there was physical proximity to the consequence of the defendant's negligence.
Well, to a consequence, yes, but these tests have obviously been examined and light shone upon them in subsequent cases as to their application to the sort of cases that we're concerned with. So one needs to look at.
I mean, it seems to me, anyway, speaking only for myself, that if your submission is that what we get out of Alcock is that the limitation on secondary victim cases is purely the control mechanisms, then you lose, because in this case, it's perfectly clear there was tremendous proximity between the secondary victim and the consequence of the negligence.
Well, my Lord, that's part of answering the question about whether there's a duty of care at all. And my Lord is, of course, right that you have to look at whether there is, the defendant ought to have had the secondary victim in their contemplation.
Well, what I'm trying to get out of you, if I may respectfully say so, Mr. Baggett, is why you shun what I'm putting to you. There must be a reason why you must think that it's wrong, but I need to know why.
But I'm not shunning it at all. I'm saying that should be the focus on whether there's a duty of care at all and that there isn't here.
Yes, but you say it's only because in Alcock they said there are special limitations on secondary victim cases and they're the 5 ones set out as control mechanisms. But I'm putting to you that there is a much more fundamental point here, which is the question of proximity between claimant and defendant, which is what Lord Oliver says, as you claim us.
Well, there's that of course, that has to be answered as well, yes. I
Well,
didn't make that clear.
Well,
Well, that's the point. Does it have to be answered as a separate question?
Well, it's the only question, is there a duty of care at all? And in answering that
the
question...
big question is there a duty of care? And there are 2 elements, that reasonable foreseeability, which we can put to one side, that's not an issue, and the other is proximity. What I thought you'd agreed with me earlier, but you see why my Lord is puzzled by it, is that these cases establish that the criteria for proximity in a secondary victim case are the control mechanisms. The control mechanisms are the criteria. That's what I was suggesting to you, and I thought you were agreeing with it. But then if you do agree with it, there's nothing left. There's not a further question about is there proximity as well.
You can't agree with the
because
state.
if they are the test of proximity, you've answered the test.
Well, it's part of the way that the court answers that test, of course.
Only
looking at
part of it.
control mechanisms, but the underlying postulate, as Lord Oliver calls it, is there a duty of care at all? Is there a should the defendant have had the secondary victim in contemplation? So, my Lord, I think we are agreeing with one another, but we.
Well, I don't think
I'm sorry if
you
I
may be agreeing with my Lord, but you can't agree with my Lord and with me. If you maybe need to go away and think about it and tell us what your submission is as to what you say the law that emerges from these cases. My lady asked you, what is the law that emerges from these cases? And you answered it as if you agree with my Lord, which is why I put to you, well, do you agree with me? And you said you agreed with me, but you can't agree with everybody when they're conflicting propositions. I mean, it's a simple question. Is the question of legal proximity answered by the 5 control mechanisms exclusively or not?
Well, it's part of the question, but my Lord, I would agree with you that you have to look at, is there the question of whether the defendant ought to have had the classical formulation, ought to have had the secondary victim in contemplation, because that is, of course, the overarching question. So yes.
That's why I put the RSJ point to you earlier. Because the RSJ point highlights that and shows that it's completely impossible that the architect would have had within his contemplation somebody watching it falling down.
Yes, well, that's absolutely the point.
But you were reluctant to accept it then and said it was a different kind of case and it was all very complicated and you didn't know.
Well, it's still a relevant question. One just has to be careful because it's on different facts and doesn't immediately involve the primary victim. But yes, you're looking at answering that question at the time. What should, if one paused time, what should the defendant at that point have had in contemplation?
But that's really, it's not actually a factual question. It's a normative question. It's to some extent a factual question. If you asked, could the architect have foreseen that if he didn't build the design the RSJ properly, the door might collapse and somebody, yes. Could he reasonably foresee that someone might be standing under it? Yes. Speaking for myself, I don't find it that difficult to say, could he reasonably have foreseen that the person who was standing under it was accompanied by his wife, who was one pace behind and saw the whole thing happen? Yes. But that's why reasonable foreseeability is not a great test.
Well,
it's more a question, it's more, as I say, a normative question of what ought to be the limits of the law be as to where the duty of care should be. And there may well be an answer that in that particular case, you should owe the duty only to the person primarily injured, not to the wife standing 3 paces away and being shocked by seeing it happen. But then you've got to face up to the fact that's what you're saying.
well, yes,
And it's not, you don't get that out of these cases.
Well, you do get the proposition, my lord, with respect that the reasonable foreseeability simpliciter is not enough. That's
Yes, but that's not really what we're here about. Everyone agrees that. You need proximity, which is a limiting factor on reasonable. You can foresee some things and yet it not be reasonable or within the policy of the law to give you a to create a duty of care to prevent those things.
Yes, that's the position. Yes.
You see, I've been trying to get you to Mr. Justice Chamberlain's judgment, because when you look at Mr. Justice Chamberlain's judgment, he actually reasons the case in drawing exactly the distinction between my lord and I. He says it's all to do with the control mechanisms, and this is another example of a case in which the control mechanisms are satisfied. And it's just a new case, and there's nothing strange or new about it actually as a matter of law. But that's only right if those control mechanisms are exclusive.
Yes, well, absolutely, that's the starting point, and that was my submission to him, that you've got to look for that duty of care. You can't just have a tick box exercise saying here's a consequence. Does that satisfy the control mechanisms?
You see, if we take the exceptional step of looking at your skeleton argument, you identify at paragraph 14, the question I've been putting to you, the key question which should be posed is whether in each case the claimants have a realistic prospect of proving that the defendant owed them a duty of care, Taylor and Novo. And then you say, at ground 1, that the judge was wrong to hold there was a relevant event on the facts of this case, which is not the same point at all. And then you go off on ground 2, if he was right to hold there was a relevant event, he should have gone on to hold that the event was the negligent treatment in hospital, etc. But your grounds of appeal don't address the point you make at paragraph 14.
Well, my lord, the judge has analysed the case in a particular way, but I'll have to look again at the detailed grounds, but the squarely the question we started with is there a duty of care at all? And I would agree that's the fundamental question that has to be answered. If there's not, then the claims can't succeed. It might be helpful to look at Taylor and Somerset and Taylor and Novo, because those are the cases which fall under relevant circumstances. I'm just conscious I was looking at the House of Lords cases, and the only case I haven't looked at is White. But the only 2 points really I take out of that are thus far and no further, the well-known.
Lord Steyne.
Yes, Lord Steyne, thus far and no further. And the stress in Lord Hoffman's judgment about the fairness between classes of claimants and the importance of that. And could I just take you to that point before we move on? That would be by going to page 296 in the authorities bundle, please. So let's see, Lord Hoffman is identifying the reason why it wouldn't be appropriate to extend the law in the way that's sought, because it would be unacceptable, and he goes on to explain his reasons why. And after excluding various other possibilities below E, 3 lines below E, he says, he in the sense of the ordinary person, would think it unfair between one class of claimants and another at best, not treating like cases alike, and at worst favouring the less deserving against the more deserving. So that's a point which is picked up by Lord Dyson about the importance of looking at the effect between different classes of claimants of different decisions and rationalising those together, not just saying, well, one situation seems fair, but making that comparison. I'll then take you to the Taylor and Somerset decision, which is at tab 4.
I mean, I'm sorry to bang on Mr. Baggett, and I will promise to shut up now, but this point that we've been debating is very clearly highlighted at the end of paragraph 61 and the beginning of paragraph 62, which I think contains the ratio of Mr. Justice Chamberlain's decision in this case, where he says that the critical question, whether the parties were in a sufficiently proximate relationship, is to be answered not as you suggest, by an appeal to basic intuition, but by asking whether the control mechanisms are satisfied. And that is what he says. And if he's right, and my lord is right in the way he puts it, then that's the answer. If he's wrong, and there has to be more than that, but there has to be proximity in the legal sense between the claimant and the defendant, then that's much broader, and that's what Lord Dyson was saying.
Yes,
But to me, it's a fairly basic question of law that we're being asked to decide, but it's not the way you really put it. You don't seem to want to put it that way.
Well, that is the question. I've started always my submissions in these cases with saying we're looking at whether there's a duty of care owed at all. So I'm sorry if that's been unclear, but that's
not in your grounds of appeal. That's the point. Anyway, okay, keep going with the cases now.
So Taylor and Somerset, this is the key decision on which We say it's important because there is an attempt to narrowly define the scope of the Taylor and Novo decision by saying it's a paradigm accident case, but that's, my submission, it's not an appropriate way of distinguishing that case in some way because it's decided by making a choice between two competing clinical negligence cases and making the choice to accept as correct the findings in Taylor and the case of Taylor and Somerset. This was a clinical negligence claim where the claimant's husband had suffered a heart attack whilst at work many months after he'd been treated by the defendants for a heart condition. They'd negligently failed to diagnose or treat his serious heart disease and admitted that they were negligent in doing so. He had a heart attack and died at work. He was taken to hospital and his wife saw him at hospital within an hour, but having been told by a doctor that her husband was dead, and then she saw him in that state and brought her claim on the basis that she was a secondary victim. Page 180, there's no letters, but it's the third paragraph. The negligence which caused Mr. Taylor's death was one of failure many months before to diagnose and treat his serious heart disease. Then it sets out the unexpected heart attack, taken to hospital, went to hospital arriving about 3:20. After a short wait, she was told that her husband had died, and a few minutes later she identified his body. Can I then take you to 183?
Well, we do need just to notice the way in which Mr. Justice Earle characterised the issue before him. He treated it as simply an immediate aftermath case. Was it immediate enough? It may well be if you look at the rest of his reasoning, there's a bit more in it than that, but still that's what he was saying.
He was saying that at that point I would agree, but there is more in it than that, yes, my lord.
And before you get to 183, at 182, he is summarising his understanding of the decisions in Alcock and McLaughlin.
Yes, and my lady's absolutely right.
And what he imports into it is this concept of external, which is nowhere to be found in either authority.
Well, that's how he sees it, certainly.
But it's not there, it's not in the earlier authorities.
Well, it's one reading of the earlier authorities.
But what does that, I don't even know what it means. What does it mean?
It's saying that there has to be some event external to the primary victim, we would say, some incident rather than just some event such as a heart attack.
You mean external to the secondary victim?
External to the primary victim.
Well, is a heart attack external to the primary victim? And what does that mean, as my lord asks?
Well, I think he's alluding to something like a car accident or a particular event which is external to the primary victim.
Would you say that's correct, as a matter of law?
Well, that's the first ground of appeal.
Concept of externality.
Yes, that's the first ground of appeal, that because this decision was accepted by Lord Dyson, that's a requirement that there has to be an external event to the primary victim. That's...
How, in a clinical negligence case, can there be an external event to a primary victim?
Well, it's going to make those cases difficult to be successful, and that's why there are a few reported cases, I would submit, in that arena. But one can imagine a situation where someone is having a scan and a machine explodes. There's an external event there which causes an injury. It's not.
So you say Walters is wrong on that basis?
On that basis, yes, that would be correct, but that's our first round of appeal. The second round of appeal is if we're wrong about that, there is a valid explanation for Walters, which is that the point of the fit was the tort itself was a negligent infliction of damage. So my lady rightly drew attention to page 182. And first paragraph, which has a line by Lord Wilberforce in his formulation of these two constraints, clearly had in mind the most usual circumstance of which the case before him was an example, in which the horrific consequence of the breach of duty consists both of an external traumatic event such as an accident and the suffering in it of violent injury or death. Then moving further down to the next paragraph, which is black-lined, there's a sentence starting, the tenor of all the speeches in Alcock is to emphasise, without drawing precise boundaries, the strictness of the proximity test and to confine its application to an external traumatic event or its immediate aftermath causing shock. That's a passage which doesn't appear in the judgments of Mr. Justice Chamberlain, and is part of the reason, I would say, why he was incorrect to conclude that you could explain this judgment as only requiring an event external to the secondary victim, not the primary victim. And then moving on to page 183, please, towards the top of the page. All of their lordships and all considering the application of the immediate aftermath test to the various claims before them did so understandably in the circumstances of the case by reference to the accident, the disaster in the stadium, but regardless of the particular circumstance of that case, all their lordships clearly regarded some external traumatic event in addition to its primary consequence of injury or death as a necessary starting point when considering what Lord Oliver described as the essential but elusive concept of proximity or directness. Then it's important to look at what was being argued in this case. Same page, 183, final paragraph, please. Mr. Lewis, on behalf of the claimant in that case, submitted that the event to which the proximity test applies in the circumstance of this case is the consequence, namely her husband's death from a heart attack, or the health authority's negligence, of the health authority's negligence, not some incident in the sense of an external traumatic event acting on Mrs. Taylor's mind. And then moving on to the top of the next page, 184, in the first main paragraph, Mr. Hart, on behalf of the health authority, submitted first that there was no event on the facts of the case to which the proximity test could be applied. He maintained that the test required some external traumatic event in the nature of an accident or violent happening. Here, he said, Mr. Taylor's death long after the negligence which had caused it was the culmination of the natural process of heart disease, and the death, however unexpected and shocking to Mrs. Taylor when she learned of it, was not in itself an event of the kind to which the immediate aftermath extension could be attached. There was then a second submission because, of course, there was an objection taken because there was communication of the news by a third party, which was something that wasn't permissible. But then the judge goes on to say in the third main paragraph, in my judgment, Mrs. Taylor's claim must fail for both of the reasons advanced by Mr. Hart. So the judge is accepting both of those points. Those are the ratio of Taylor and Somerset. The judge then goes on to consider the immediate aftermath extension question, exception to the general principle that establishing accident cases that a plaintiff can only recover for psychiatric injury when the accident is within his sight or hearing. Then goes on to say, after setting out those two notions, in the next main paragraph, there was no such event here other than the final consequence of Mr. Taylor's progressively deteriorating heart condition, which the health authority, by its negligence many months before, had failed to arrest. In my judgment, his death at work and subsequent transference of his body to the hospital where Mrs. Taylor was informed of what had happened and where she saw the body do not constitutes such an event.
So is he accepting the heart attack was an event, but in fact, on the facts of this case, what thereafter occurred to Mrs. Taylor was not an event?
No, my lady, he's saying that the heart attack here couldn't be an event. There's a separate reason that what happened to Mrs. Taylor, in that she was told and used by someone else, was a separate and standalone reason for the case failing.
No, I'm sorry, I'm sure the fault is mine. He's actually said there was no such event here other than the final consequence.
Yes. No.
So he appears to be accepting, but tell me if I'm wrong, he appears to be accepting that the final consequence, namely the heart attack, could have constituted an event. Have I got that wrong?
I think so, in respect, my lady, because he's saying there wasn't an event here, there wasn't a qualifying event.
Right.
And the death couldn't be it. The heart attack couldn't be it because it was simply the final consequence of the deteriorating heart condition. Use of the word consequence there might be a little confusing because
it reflects what was said by Lord Wilberforce.
It
in
does,
McLaughlin, yes.
but I think he's using it, I would submit anyway, he's using it in the sense of the consequence of the deteriorating heart condition, not in the sense, he can't be using it in the sense of the consequence of the negligence because he's saying that it can't be, there is no event.
So the claim would have failed even if he'd had the heart attack at home in front of his wife.
Yes, if you change the wording there where it says in that paragraph there was no such
Which paragraph are we looking at?
Sorry, the one that says halfway down, page 184, there was no such event here other than the final consequence. If one changes the words other than to only, there was no such event here, only the final consequence of the progressively deteriorating heart condition, then perhaps becomes a bit clearer. He's saying that's all there was. There's no qualifying event because there's nothing to which you could apply the proximity test. There's no external traumatic event. So what I'm going to say about this is it's wrong to focus on the death alone as some sort of starting point, trying to trace back from that. And if that observation is right in this case, as accepted we say in Taylor and Novo, then it provides an answer to these appeals where in all of those cases the death, tragic as it was, of each of the primary victims was simply the culmination of a medical condition which negligently the claimants say hadn't been addressed or arrested.
Well, then Walters is wrong.
If Taylor and Somerset is right, and that's the right way to read this case, then Walters would be wrongly decided, yes. I'll then take you to the decision in Taylor and Novo, which is behind tab 14. Sorry, I apologise. So in this case, I've already touched on the facts, but the claimant's mother, Mrs. Taylor, had an accident at work when a colleague caused some racking balls to fall over, injuring her head and foot. She was we see at 4260 in the judgment of Lord Dyson, then Master of the Rolls, that she was apparently just above D. She was apparently making a good recovery when, on that date, she suddenly and unexpectedly collapsed and died at home. Her sudden collapse and death were due to a DVT, which caused a deep vein thrombosis, which caused a pulmonary embolism, and those injuries were themselves sustained as a result of the accident. They were caused by the accident. Her daughter, the claimant, didn't witness the accident at work, but she did witness the mother's death 3 weeks later and suffered a psychiatric injury as a result. And this was squarely a case about proximity in space and time. Could proximity to the death 3 weeks later give rise to a valid claim in the sense of, was there a duty of care owed by the defendant to Ms. Taylor? And that case was answered yes at first instance and no on appeal. At 431, please.
So can you give me paragraphs?
Paragraph 11. Lord Dyson is considering Taylor and Somerset, the case we've just been looking at, sets out the facts of that case. And this paragraph will be important because at the end of the judgment, Lord Dyson goes on to say that the reasoning in Taylor and Somerset was correct and refers back to paragraph 11. Lord Dyson sets out the facts. Just above D, the defendant's been treating him for many months and negligently failed to diagnose or treat his serious heart disease. Admitted she suffered nervous shock as a result of what she'd heard and seen at the hospital. And Mr. Justice Auld held that the death was the final consequence of negligence by the defendants many months earlier. And then sets out the passages we've just been looking at. So Lord Dyson sets out the two notions implicit passage, just a few lines above F, and includes the passage, there's no such event here other than the final consequence that we were again just looking at. Then Lord Dyson looks at the case of Sion and Hampstead, a strikeout case where a father claimed damages in respect of psychiatric injury caused by a hospital in caring for his son, and the father had stayed with him for 14 days watching him deteriorate. The judge had struck out the case, but the case went on appeal to the Court of Appeal. It had failed because there wasn't any trace of shock in the medical report, so any other observations were going to be obiter in that case. But if one goes over the page onto page 432, a continuation of paragraph 12, just below the black lining, there's a sentence starting, but he, and that's Lord Justice Peter Gibson, also dealt with the defendant's submission that the claim could not succeed because the injuries and or death of the plaintiff's son did not qualify as a relevant event for the purposes of a valid secondary victim claim. The defendant relied on the decision of Mr. Justice Auld in the Taylor case. Lord Justice Peter Gibson said he was not persuaded by this argument. He acknowledged in most of the decided case there had been a sudden and violent incident resulting from the breach of duty, but went on to say it's the sudden awareness violently agitating the mind which is occurring, which is the crucial ingredient of shock. He then gives an example of the wrong medicine being given to a patient and that causing shock to someone who finds the body. Then at paragraph 13 says, since Lord Justice Peter Gibson agreed with Lord Justice Thornton there was no evidence of nervous shock, what he said in relation to the Taylor case was not necessary for his decision, it was obiter dicta.
So effectively, he's saying it's wrong.
Yes, I think I would agree that it's a polite way of saying it's wrong. So he's accepting the reasoning of Mr. Justice Halls, as we'll later see.
I mean, it's important that he does say it's wrong because if it was right, it's fatal to your appeal.
If the Sion case, yes. What?
I mean, if Lord Justice Peter Gibson's dictum were correct,
Yes. Must be right.
you accept that, yeah.
Then at 436, paragraph 26, this is where Lord Dyson sets out the two different meanings of proximity. So legal proximity, distinct and narrower from reasonable foreseeability, the neighbour principle.
Can I just draw your attention to 25? He says there, this case does not raise the questions of the kind which typically arise in secondary victim cases, close tie of love and affection, close in time and space to the incident for which the defendant was negligently responsible, and directly perceiving the incident rather than hearing it from a third person. The issue is whether the death of Mrs. Taylor was a relevant incident for the purposes of her claim as a secondary victim. If it was, then her claim would succeed, because on this hypothesis it would not founder on the rock of any of the control mechanisms. So in other words, I think he's saying this is outside the control mechanism. And then the most important sentence, I think, I accept the submission of Mr. Corey Wright.
Yes.
That Miss Taylor must show, in order to succeed, there was a relation of proximity between Novo and herself.
Yes, that's
In
my
other
Lord's
words-
point.
In other words, what he's saying is this is not the usual situation of proximity within the control mechanism sense. It's a case about the first sentence of paragraph 26.
Well, he does in paragraph 25 mention in the last line.
I know he does, that's the problem.
He does link it to the control mechanism.
Well, I don't think he does. I think that's the whole point. I think the sentence that's difficult for that proposition is the issue raised in this case is whether the death was a relevant incident for the purposes of Miss Taylor's claim as a secondary victim. But that may just be a question of formulation, because when he comes to actually decide the case, it's at 26, where he says the question is whether there was proximity between the defendant and the secondary victim. Proximity is in two senses, deals with all that. And then at 27, in secondary victim cases, the word proximity is also used in the time and space element as one of the control mechanisms. But I accept the submission of Corey Wright that the correct question is whether Taylor and Novo were in a relationship of proximity in the legal sense. And that's why he decides it as he does. And that's my analysis of it. You tell me if I'm wrong.
I think that's right, but he is linking it to the control mechanisms in the sense of he looks at in paragraph 25, he's looking at was she close in time and space to the incident for which the defendant was negligently responsible.
He's really not, Mr. He's really not, Mr. Baggett. It's the whole point of his reasoning. This is why this fixation about the two reasons he gives later is so confusing.
Well, he's saying there the case doesn't raise the question about closeness in space and time to the incident for which the defendant was negligently responsible. I think what he's saying there is it's not an aftermath case because this is not a case concerned with is Ms. Taylor within the aftermath of the accident at work.
Well, I'm not
no one's
sure.
suggesting that.
Surely he's saying, no, Mrs. Taylor died in Ms. Taylor's presence. The incident for which she was legally negligently responsible was the death. And there was no proximity problem because Mrs. Taylor was close to that in both time and space. She was there. And he goes on to say, so there isn't a problem with any of the control mechanisms, but the problem is the claimant's got to overcome a further hurdle, namely proximity in some wider sense.
Well, he does say in the preceding paragraph, in paragraph 25, the issue raised in the case whether the death of Mrs. Taylor was a relevant incident for the purposes of her claim as a secondary victim. So he's looking at...
No, that's what I've just drawn your attention to. That's lax language when you then see that twice he says, I accept the submission of Mr. Corey Wright as to what the real issue is. In order to succeed, Taylor has to show there was a relationship of proximity between Novo and herself, and then again at 28, I accept his submission. The correct question is whether Taylor and Novo were in a relationship of proximity in the legal sense, which he's just distinguished from the control mechanism sense. Having answered, as my lord points out, the control mechanism question, which obviously there was quite sufficient proximity, as there is in this case.
But my lord, at paragraph 28, he goes on to say, just 2 lines below D, in the context of claims by secondary victims, the control mechanism of the judicial response to how this area should be defined. This has involved drawing of boundaries which have been criticised as arbitrary and unfair.
So which paragraph are you now looking at?
Paragraph 28.
Yes, yes.
You were drawing my attention to the acceptance of the submission that the correct question is about legal proximity. Of course, that must be right. Depends on the court's perception of what's reasonable, but then the next sentence, in the context of claims by secondary victims, the control mechanisms of the judicial response to how this area should be defined, this has involved the drawing of boundaries which have been criticised as arbitrary and unfair. That's what the courts have done in an area where they've had to fix the ambit of liability without any guiding principle. So I don't think he's excluding the fact that the control mechanisms are
No, they
part of the
apply.
consideration. They apply, and they're part of the...
But they're not the only test that applies.
No, but
There's a further limitation. And then he says in 29, very importantly, the use of the word event has the tendency to distract.
Yes.
That may be regarded as an understatement. This was an accident with 2 consequences. There was clearly a relationship of legal proximity between Novo and Mrs. Taylor. And if she'd been in physical proximity to the accident, that would have been fine. But to allow Miss Taylor to recover as a secondary victim would be to go too far. And then he gives his 2 reasons.
Yes. He's specifically saying that if she'd been present at the work accident, then she would have qualified because she would have been close in time to that particular incident. So he's using that. He's addressing the control mechanisms as well as the overarching question of legal proximity.
And his 2 reasons are, 1, it's too far away in time, so there's no proximity. Because he says this suggests the concept of proximity, brackets I would put in between the claimant and the defendant, cannot be reasonably stretched that far. And the second reason is in Frost, thus far and no further.
Truth, it's really only one reason, isn't it?
Yeah.
The first reason is the actual reason why it doesn't work. The second is, as it were, a policy reason that we shouldn't be. The second reason really reinforces the first.
Yes, he does say, to be fair to Lord Dyson, that the second reason is closely connected with the first at the start of paragraph 31.
Yes, right. He calls them interrelated. But the real point that comes out of paragraph 30 is there was too long between the accident, the breach of duty by Novo, and the suffering of the injury. That argument would be the same whether or not he hadn't suffered any noticeable injury at the time of the original accident.
But
Sorry.
I mean, that's right, but the reason why the time matters is because it affects the question of whether there's a approximate relationship
No, so
between defendant and claimant.
it could be said that this different new time point, addressed for the first time because this is the first, at least case at appellate level where the issue came up, is a further control mechanism. If by control mechanism you simply mean one of the limiting criteria that you need in order to establish proximity in this class of case, you brought another one.
Well, my lord, I would describe it more as trying to set the limits of how far it can be stretched, because no one had tried before this to say that it could be stretched to 3 weeks in this way. But it's important to highlight, I don't think we're disagreeing about it, but can I just highlight the way that it was analysed in paragraph 29, because Lord Dyson looked at it as the negligence having two consequences which were separated by 3 weeks in time.
Yeah, but he does so in order to say there was a relationship of legal proximity with the first claimant, but not with the secondary claimant, because of the time. And that's then reflected in his first reason, as my lord has pointed out. So it is pretty well all of a piece. I mean, the problem is the confusing discussion of events, which he says is confusing. And then he makes it a bit more confusing by approving Mr. Justice Ald, which he has no need to do, because the ratio is the ratio.
Well,
So, I mean, I would suggest to you that Mr. Justice Ald is a total red herring here.
well, certainly Taylor and Novo is the guiding decision, which I say is an answer to these cases. Part of that reasoning in that case is obviously Taylor and Somerset, but of course Taylor and Novo provides the answer.
Well, I think my lord is putting you, it isn't part of the reasoning, or it's not part of the dispositive reasoning. It's an add-on at a point when he's already reached his decision. But
Well, it could be a second reason for his decision in theory. I don't know whether you say that's the case or not.
Well, he does say, one looks at paragraph 33 on page 438, it follows from what I've said. So he is linking the decision in Taylor and Somerset to his ratio. He says it follows from what I've said, immediately before that, i.e. the ratio, the reasoning of Mr. Justice Ald was correct. And he goes on to say, the observation of Lord Justice Peter Gibson and Sion Rope's dictum not binding on this court, and I would agree with my Lord's observation that that's really code for I don't accept them.
Yeah. Well, we can come back to that. Yeah.
you should perhaps have said, it follows from what I have said that in my view the result in Taylor was correct. I'm not sure that, speaking for myself, that his reasoning is the same as that of Mr. Justice Ald, so it comes to the same place.
I don't think that's contentious, because Mr. Justice Ald is all about events.
Quite. Well, it may not be contentious, but unfortunately it's what he has said the reasoning.
Yes, I know.
But he also does stress, I don't want to overlook this part of it, is the analysis that he uses in paragraph 30 of looking at if the judge is right in this case, the point about if the death had occurred months, possibly years after the accident, subject of course to proven causation, the secondary victim will be able to recover.
Sorry, where are you reading?
Sorry, it's paragraph 30, 437, just above age.
Yes.
So he's making this comparison. It seems to me the judge is right.
It's
He's
odd.
been able to recover even if it was months or years later.
I do see the force of the argument, and that is the ratio. That's the end of the matter. In a sense, it's not very much discussed. It's just taking it for granted. Well, if it's long after the event, there can be no relationship of proximity. That's right. When it's long, I don't want to use the word event. If it's long after the breach of duty, there can be no relationship of proximity. I wouldn't have thought it was self-evident, but he treats it as self-evident. And if that is his reasoning, we're bound by it. Why is
we're
it
bound by it
self-evident?
unless it's wrong.
Yes.
Unless it's wrong or pericuria. I mean,
Well,
yeah. I mean,
because
unless Walters, the reasoning in Walters is inconsistent with it, and he should have followed Walters.
yes.
My lord, I think the explanation of that is he's already looked at the strictness in the body of the judgment. He looks at the strictness of the control mechanisms. He later...
Yeah, but that's all irrelevant because the existing control mechanisms were not addressed to this question. This is the first time, if we ignore Taylor and Somerset, where this question had ever arisen. And he recognises that. That's, my lord has pointed out to you, that's the whole point of paragraphs 24 and 25, or 25 and 26. But, he says, there isn't a relation to proximity looking at it apart from the existing control mechanisms because the lapse of time between the breach of duty, he says the accident, but that is at the breach of duty, and the shocking event is too long. And I sort of get that in a gut sense, but you might have expected it to be rather more fully developed, because it isn't self-evidently right.
Well, my lord, it's against the backdrop of an exceptional category of claim.
Yeah.
Where in McLaughlin, 2 hours afterwards at hospital, at the margins of what the law would allow,
Yeah, but that's
a different
factual situation. But in one sense, it's consistent with Lord Justice Ward's case, because Lord Justice Ward strove to find proximity by identifying a single event.
It was the seamless event, wasn't it?
Yes.
Seamless.
But he would have had, I think, if I've understood my lord correctly, he could have had another route. If the claimants are right here, he needn't have worried about treating it all as one event. He could have said, it doesn't matter, it's another event, and 36 hours have intervened, because it's still a consequence. So, the point in a way sense in your favour, that the way in which Lord Justice Ward had to argue, or thought he had to argue it, is a recognition that there is no other route.
Well, yes, and that chimes with the way that Lord Dyson looks at Walters. If you look at paragraph 35 on page 439, he looks at that case, and as my lady points out, that case was all about, can you stretch an event? It was nothing to do with identifying the event. It was about, can you stretch an event to 36 hours, or is it a frozen moment in time? And the court was satisfied you could stretch an event if it was a seamless tale. Lord Dyson here in the final couple of sentences of that paragraph says the question whether the death being a separate event was a relevant event for the purposes of a claim by a secondary victim didn't arise in Walter's case.
Can I just ask this question arising out of this whole area? Let's go back to the example of the negligently designed door. And everyone accepts that the architect owes a duty of care to people walking under that door at any time in the next, up to the end of the limitation period, effectively, because it may fall on them at any time. So there's no problem about lapse of time in a case of that kind. What's the policy reason for saying there should be a problem about lapse of time for the secondary victim, the wife who is 2 paces behind and isn't injured herself, but sees her husband crushed to death in front of her? I myself find it difficult to see intuitively why the fact that her injury is psychiatric and in that sense secondary means that time should make all the difference in her case when it makes no difference as regards the duty of care to the primary victim.
My Lord, I would say it's not to do with the nature of the injury. It's not because it's psychiatric injury. It's to do with the fact she's a secondary victim, not a primary victim.
Yeah, but that's really what we mean by a secondary victim, someone who suffers a psychiatric injury from seeing a physical injury to someone else.
Yes, but there's someone who only has a claim exceptionally, where the law does not normally grant a remedy to someone who only has a claim by reason of their relationship to the primary victim, can bring a claim. So it's all of the piece with the strict limits on those claims, not allowing them just under the normal test for a primary victim, but limiting them, deliberately saying some of those
It's very strict. She's got to be there. It won't be good enough if she comes across him in hospital anyway. All those control mechanisms are satisfied. But she is there. He's 2 paces in front of her.
Yes, but the law has also said you're looking at what's in reasonable contemplation and saying that.
But why isn't it in reasonable contemplation that she will suffer such an injury just as much as that he will be killed?
Well, because you can envisage foreseeably any individual being in that scenario, but you need to draw some boundary at some point.
No, of course that's right. That's why a mere bystander who sees this whole horrible accident can't recover. But assuming it's the wife, so all the existing control mechanisms are satisfied, why should the lapse of time between the breach of duty and the suffering of the primary and secondary injury at the same time be a reason why you shouldn't owe a duty of care to both victims?
Well, it partly comes back to the point about fairness between classes of claimant, because if you've got someone who 3 years afterwards can recover because they are proximate to that instance, but someone where the builder is still building the doorway and it collapses the minute he walks away, when someone walks under the door, if that instant happens, it's much more immediate, and there's a secondary victim who comes on the scene shortly afterwards, but just outside the immediate aftermath. That individual in that very short, narrow window, something happened very quickly, can't bring a claim. If the law then says that someone who is much more removed in time, much further down the line, much less in contemplation, 3 years later can bring a claim, that's what Lord Hoffman and Lord Dyson are describing as what the law would object to, what the reasonable person would object to, because it's not fairness between classes of claimants.
I wonder if the answer to my Lord's question is that because all the nervous shock cases arose from accidents and not from medical negligence or architect's negligence, the proximity question, the legal proximity question, has been limited by a further control mechanism for secondary victims, which is illogical, and probably when we look at medical negligence and we look at other kinds of negligence, we see that it doesn't really work or make a logical scheme for the law, but we're told we're not allowed to make any extension beyond where we were. So we can't make any extension beyond where we were. But it's not a happy situation, as my Lord points out.
No, but if there is
your answer, if I may say so, very energetic and insightful, doesn't really get to first base because there's no logical answer.
Well, it's providing a limit to the claims so that they're not stretching to the limits of human imagination, to use the terms in the authorities.
You say thus
That's
far and no
partly fine.
further.
Yes.
Well, I see that.
So that may be a good time for us to break and cogitate on it over lunch, and we'll resume at 2 o'clock, Mr. Packett.
All rise.